What is affirmative action? In its general terms, it's a system that's intended to diversify various parts of society.
Because a lot of people know that the case involved affirmative action and discriminating on race, but they didn't know how the schools actually used race in their admissions policies. And there are only two compelling interests that are permitted to resort to race-based government actions. Number one, to remedy specific identified instances of past discrimination that violated the Constitution or a statute. Race consciousness in admissions is imperative to providing effective public service, leaders in politics and business, and a diverse legal profession to ensure the justice system.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Ebony Morris and Valerie Fontenot. Ebony S. Morris is an attorney at Foley Mansfield's New Orleans office and regularly handles general liability defense, workers' compensation, mass tort and product liability, and premises liability matters. Her clients, which include educational institutions, Fortune 100 and 500 corporations, insurance companies, small businesses, and individuals, trust her to successfully resolve matters which arise during business. Ebony has extensive experience in fact and expert witness discovery, motion practice, settlement, and mediation. Valerie Fontenot practices litigation of civil matters, particularly the trial and appeal of healthcare matters, including medical malpractice defense and regulatory and compliance. Valerie has significant experience in the litigation and appeal of general liability cases in an array of areas, including high-value motor vehicle accidents. Valerie's areas of expertise have provided her with numerous opportunities to interact with many expert fields, including medical causation, vocational rehabilitation, life care planning, biomechanics, and economics. The webinar presentation that you're about to watch will be approximately 1 hour, and once that's complete, our speakers will be taking live questions from the audience. If you have any questions that come up for Ebony or Valerie during the presentation, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. Now, without further ado, here are Ebony and Val to discuss the attack on DEI, safeguarding corporate DEI initiatives, post-Supreme Court's affirmative action decision.
Good afternoon, everybody. My name is Ebony Morris, and I'm an associate attorney with Foley and Mansfield in the New Orleans, Louisiana office. My practice areas are toxic tort and talc litigation defense. And welcome to our webinar, The Attack on DEI, Safeguarding Corporate DEI Initiatives, Post-Supreme Court's Affirmative Action Decision. And my co-speaker today is Ms. Valerie Fontenot. Valerie, do you want to talk to the audience?
Sure. Welcome, everyone. My name is Valerie Fontenot. I'm a partner at Freelo LLC, also here in New Orleans. I practice in the areas of medical malpractice and healthcare litigation, specializing in the trial and appeal of healthcare matters. And both Ebony and myself like to chat on D&I topics, so we hope you are passionate about it as we are and enjoy the webinar today.
All right, y'all. So I'll give you a brief background of this discussion today. We actually wrote this as an article for the Defense Research Institute. Val and I are both members of the Diversity Inclusion Committee, both steering committee members, and I'm the vice chair of the diversity seminar for this year, and she is the expo chair for the seminar as well. And so we took this topic and rewrote it for The Voice, which is a quarterly publication for DRI, or a monthly publication for DRI. And so it kind of went from there. And we also had this discussion for the New Orleans Bar Association as well, which is local. And so we are doing this on a national scale. So today, here's our agenda. We'll give an overview of affirmative action. We'll talk about the historical background as well as some historical attacks on DEI and kind of how we got to the recent decision with the Supreme Court. And Val will go through that decision, and we'll also talk about she'll give an in-depth discussion of the decision. And we'll talk about the response to the Supreme Court's decision, its impact on the legal profession, and some ways that we can continue to safeguard DEI initiatives in light of the court's decision. So again, we're going to talk about affirmative action. What is it? We're going to go through some past cases, impact on college admissions, and also impact on some DEI initiatives. So, what is affirmative action? In its general terms, it's a system that's intended to diversify various parts of society. So affirmative action originated in 1961 when President John F. Kennedy issued Executive Order 10925. 10925 is a policy that ordered government contractors to ensure that applicants are employed and employees are treated fairly, regardless of race, color, creed, and so forth. In 1965, President Lyndon B. Johnson issued Executive Order 11246, which superseded Executive Order 10925. So 11246 required government employers to hire without regard to race, religion, and national origin. And some areas where you see affirmative action is obviously in school admissions, so in the public sector, in professional positions, so within our workplace, and also when we're talking about access to housing and financing. So historically, affirmative action was intended to help bridge inequalities in employment and pay, increase access to education, and promote diversity. But now, doesn't necessarily mean that it hasn't been attacked. So we're going to go talk through that. So some historical attacks on affirmative action. These are just the biggest cases, right? Or the most known cases, but obviously there are other cases where affirmative action has been attacked. So the first one is the Regents of the University of California versus Bakke case. In the Regents case, Alan Bakke, who is a white male, he applied for admission to the University of California Medical School, and he was twice rejected. Now, the school reserved 16 spots in place for each entering class. They reserved 16 spots for qualified minorities for each entering class. So Mr. Bakke, he contended that he was excluded from admission because of his race. And the court held that the school's use of a racial quota violated the Equal Protection Clause of the 14th Amendment. But the court did hold that race could be used as a consideration in admissions decisions. Next, we have the Grutter versus Bollinger case from 2003. That involved Miss Barbara Grutter, who's a white resident in Michigan. She applied for the admission to the University of Michigan Law School and was denied admission. The law school argued that it used race as a factor in making admissions decisions because it served a compelling interest. You'll hear that again somewhere later on in the webinar, but it served a compelling interest in achieving diversity among its student body. The district court struck down the school's use of race, but the Court of Appeals reversed that decision and held that, the law school again had a compelling interest. The Supreme Court affirmed the appellate court's decision and held that the school's policy did not violate the Equal Protection Clause of the 14th Amendment. Then you have Fisher versus University of Texas at Austin. I don't have the year on there. I think it maybe was 2016
was when the final decision came out.
The final decision, but the case was going on when I was in law school, and I think Val was either still in law school or maybe just graduating from law school. But I remember this case very vividly. So there were two decisions, Fisher 1 and Fisher 2. But in that case, Abigail Fisher, a white woman, applied for admission to the University of Texas and was denied admission. Fisher, she argued that the school's use of race as a consideration in admission violated the Equal Protection Clause of the 14th Amendment. The Supreme Court, in a 7-1 decision, held that the 14th Amendment permitted the use of race in admissions decisions, but only under a standard of strict judicial scrutiny. So, in other words, the policies must be reviewed under this standard to determine whether or not that policy is precisely tailored to serving, magic words, a compelling governmental interest. So again, these are just a few cases that historically show the attacks on affirmative action and the different challenges to affirmative action. And for at least over 30 years, the U.S. Supreme Court has essentially held that race could be considered as a factor when you're talking about admissions into universities and into professional schools. And so now Val is going to take us through an in-depth discussion of the recent decision with Students for Fair Admissions, Inc. versus President and Fellows of Harvard College and also University of North Carolina.
Okay. So for the purposes of this webinar, I'll likely call it SFFA versus Harvard or SFFA versus UNC because there's a lot of words to keep saying Students for Fair Admissions, Inc. So generally, SFFA is an organization that sued on behalf of predominantly Asian students at Harvard and UNC to prevent the schools from considering race in the process. The Asian students contended that they were being discriminated against at a higher rate, and so they wanted to bring this case to the Supreme Court. The SFFA decided or took the position that the race-conscious policies violated the 14th Amendment and Title VII, and asked for a reversal of the Fisher and Grutter decisions. Of course, because we had those decisions as precedent, the lower courts, both in the district court and the Court of Appeal, ruled against the SFFA, and then SFFA took an appeal to the Supreme Court. I think it was quite a surprise when the court decided to take this particular case up as quickly as it did because the Fisher case had just been decided. So it was 2016. It hadn't even quite been, 10, it was probably like 7 or 8 years. And the court decided I want to say in the fall, that it was going to go ahead and take up oral arguments on this particular issue. And at issue in the case were the Harvard and UNC admissions policies. And so if we could go to the next slide, Ebony. Just to give you a background, because a lot of people know that the case involved affirmative action and discriminating on race, but they didn't know how the schools actually used race in their admissions policies. So the Harvard process is where they gather all the applicants. The applications are initially screened by a first reader. They give a score in 6 different categories to a student. The categories considered are academic, extracurricular, athletics, school support, personal, and overall. So in the first screening, their race is considered by the first reader. After the first reader moves through, the applications go to a regional subcommittee. The breakdown of the applicant pool by race is disclosed to the committee, and the committee reviews the applications by geographic area, and they make recommendations to a full admissions committee. Then the applicants receiving a majority of approval from the regional committees go to the full committees, and then the full committee decides who will tentatively be accepted, and you have to get a majority of the full committee's acceptance to be accepted to the school, and the racial composition of the applicant pool is also disclosed to the full admissions committee. The full admissions committee does look at 4 particular things: legacy status, recruited athlete status, financial aid eligibility, and race. So notice there's a percentage of applicants whose acceptance will be decided not on their academics or the extracurriculars, but upon those 4 particular things. Legacy status being the first, athletic status being the second, then financial aid, and then by race as the fourth. Can we go to the next slide? In the trial on the merits in the district court, Harvard identified its educational benefits to its admissions policy. Specifically, they claimed they were training future leaders in public and private sectors. They were preparing graduates to adapt to an increasingly pluralistic society. They felt that diversity would help better educate their students, and that their students would learn new knowledge from diverse outlooks. Now let's talk about the UNC policy. Similarly, UNC had a reader that originally reads the first blush of the application, and they assigned a numerical rating based on several categories, one of which was race. The reader would then make a written recommendation, and the applicant would get a substantial plus depending on their race. So you can get a 90 plus or just a 90. And then the admissions committee would review each decision made by the reader, and they could consider the applicant's race in determining whether or not they would admit a student. So next, these were the similar reasons stated by UNC for their admissions policy: promoting the exchange of ideas, broadening and redefining understanding, fostering innovation and problem solving, preparing and engaging productive citizens and leaders, and then enhancing appreciation, respect, empathy, cross-racial understanding, and breaking down stereotypes. In their briefs, UNC and Harvard use these as their compelling interests under the Grutter standard, to say these are the compelling interests they have in order to consider race as part of an applicant's application, but not necessarily using it as a quota system like was not outlawed, but banned in the Bakke case. So here we are. We have an idea of what the admissions system was doing for both UNC and Harvard. And now we're going to go ahead and get to the decisions of the majority and 2 of the dissents. So Chief Justice Roberts, his majority opinion, joined in by all of the predominantly conservative justices on the court, found that the admission systems violates the Equal Protection Clause for 3 reasons. First, they do not pass constitutional muster under strict scrutiny, and they fail to comply with the standards that race may never operate as a stereotype or be used as a negative. And Chief Justice Roberts contended that the admission system lacked a logical endpoint as required in Grutter v. Bollinger. If you will recall, Justice O'Connor in the Grutter case indicated that while she agreed with the outcome at the time, she felt that sometime in the future, potentially in the next 20 years, that consideration of race would no longer be needed because society would have advanced far enough that race would not be an issue. Well, lo and behold, almost 20 years to the day in 2023, the decision in Grutter was struck down, particularly regarding the admission systems and their consideration under strict scrutiny. Chief Justice Roberts said the goals of the admission criteria did not establish a compelling interest, and we're going to get to what they do consider a compelling interest in the next slide. However, they found there was an insufficient nexus between racial classification and purported government interest, which I would argue is not necessarily true, and we'll get into that in a little bit. Can we go to the next slide? Okay, so the standard of review that the court used wasn't necessarily Grutter v. Bollinger or the Fisher case. Rather, they used the Adirondack Construction versus Pena government contractor case that said specifically racial classifications are subject to strict scrutiny, and there are only 2 compelling interests that are permitted to resort to race-based government actions. Number 1, to remedy specific identified instances of past discrimination that violated the Constitution or a statute. And number 2, to avoid imminent risk to human safety in prisons, such as a race riot. So that second one is very specific. And the first one, while specific, I think could be a little bit broader. They also look to the case City of Richmond versus LA Crossland Company, and that was related to a preferential government contract program. And you're going to see that this kind of affects the Small Business Administration. We'll talk about that later. And that particular case specifically said that lessening or ameliorating society discrimination is not a compelling interest to justify race-based state action, because they contended that it would open the door to competing claims for relief by every disadvantaged group. And so, next slide, please, Ebony. They set out, in the opinion, it set out limitations on recognizing that equal protection disallows race from operating as a stereotype. And so for this, it essentially has to consider that if you're considering race, that race operates as a stereotype in the sense that all Black persons would think alike, or all Hispanic persons would think alike, etc. And that's what they're saying. Universities are not permitted to operate on the belief that students, because of their race, express some characteristic minority viewpoint on any issue. And because in their mind, that promotes the exact stereotype from the Equal Protection Clause. And that was their reasoning. There were 2 concurrences, actually 3, I believe. One from Justice Gorsuch, one from Justice Thomas, and then another from Justice Coney Barrett. The one that got discussed the most, of course, was the concurrence by Justice Thomas, particularly when he discusses having a colorblind constitution, and his opinion that that was the original interpretation and textual interpretation of a colorblind constitution. And he cites Plessy versus Ferguson for that contention, and you can read the quote here, and it's been provided in the materials. Justice Thomas also particularly stated that school interests are educational and not social. Although if you ask my mom when I was in college, she would probably say that's not necessarily true, but that no form of racial discrimination is helpful to social goals. And he particularly discussed the notion of social progress serving as a guide for invidious motives, and that the social goals of peace and harmony in educational settings were once the reason that provided the basis for university segregation. Next slide. Next, we're going to move on to the dissent of Justice Sonia Sotomayor. She wrote the dissent for the majority of the group. I know Justice Ketanji Brown Jackson's dissent got a lot of discussion. However, she could not participate in the decision, in the dissent in the Harvard case, because she had previously been on the board of the fellows before she became a member of the court. And so she recused herself from that particular case. And because she couldn't write for that one, Justice Sotomayor wrote the opinion for the 2 cases combined, and Justice Jackson wrote a separate dissent related to the UNC case alone. And we'll get to that one later. Justice Sotomayor and Justice Jackson both had fiery dissents, is what I would say. And they both endorsed the idea that a notion of a colorblind constitution should be rejected. And Justice Sotomayor specifically stated that the majority was attempting to cement colorblindness as a constitutional principle. However, the Constitution is not and has never been colorblind. While it may not specifically mention race, in its context, I think we all know that in the Constitution, slaves, i.e. African Americans, were identified as 3/5 of a person and were not, in fact, equal persons at the time of the writing of the Constitution. Justice Sotomayor also specifically discusses the expansive language in creating the Equal Protection Clause and its rejection of colorblind proposals. Because part of the Equal Protection Clause actually came out of the race conscious nature of the 14th Amendment, particularly as it relates to other laws that we had on the books, such as the Freedmen Bureaus Act, the Civil Rights Act of 1866. We had another Civil Rights Act of 1970. And all of those confirmed that the Equal Protection Clause permitted racial consideration to achieve the goal of equality. Next page. Justice Sotomayor, also in her dissent, criticized the majority for abandoning 4 decades of precedent. As if you will recall, the beginning of this presentation, I indicated that it was quite a surprise that they decided to take up affirmative action as quickly as they did once the new majority was cemented on the court. And because the new majority was cemented and they did take up this case, obviously they abandoned the precedent that had been set since the Bakke case. She affirmed and reaffirmed that the Equal Protection Clause authorizes a limited use of race in college admissions for the benefit that allows that comes from a diverse student body. For example, I come from a rural town. I'm a Black woman from a rural town in Louisiana. I ended up going to Tulane University, which was obviously in a city. A lot of people, there was probably about 20 to 30% from Louisiana, and then another probably 15 to 20% from Texas. And then everyone else was from everywhere else around the country, and indeed some folks from around the world. And so we had lots of differences of opinion. The school was 30% Christian, 30% Jewish, 30% other religions, or 40% other religions. And so we did have a very diverse student body, and those ideas were present in all of our classrooms. Justice Sotomayor specifically discussed whether or not a diverse student body was a compelling interest, and she identified that particular compelling interest of having a diverse student body was rooted in the principle of academic freedom and the First Amendment, and that there was nothing in the precedent that required precise interests to be found compelling by the court, i.e., the court itself could determine what is compelling. And she specifically stated that Harvard and UNC already knew that they had racial inequalities built into their system because of their histories, both of which engaged in the slave trade, and that it was built on a legacy of slaveholding, and that this was their attempt to try to root out racism and provide a more equal society and diversify their broader population of their student bodies. Because obviously, if you're considering legacy status as the number one criteria for admitting students, if Black persons weren't allowed into the school until the 60s, 70s, 80s, then you could not really have a legacy status except for maybe with the exception of one generation. Next slide. She warned of the negative consequences for Black Americans and the broader democratic systems. If you read the actual opinion, I don't have mine here, but I have it nice and tabbed and bound because I'm a nerd like that. I like those kinds of cases. It shows that the language is very broad in the case and that it can be applied to several different areas of life. And indeed, we do have, which we'll discuss in a minute, several cases relating to race as a consideration in multiple areas of life in the country, not just education. You'll see they talk about it with government-run programs and jobs and labor and employment. And Justice Sotomayor specifically discussed that race consciousness in admissions is imperative to providing effective public service, leaders in politics and business, and a diverse legal profession to ensure the justice system. And I'll get into in a few minutes when we go later why it's particularly important in certain public services, for example, in the healthcare system, which is what I do. I do medical malpractice. And you can see some cases, for those of you who don't know, particularly in the labor and delivery area where Black women die at a rate in certain states 2 or 3 times higher than white women, and how it might be affected and lowered if they have a doctor who understands some of these different issues related to a diverse population. And they, of course, would understand that more by having a diverse peer class when they're in med school. And she continued that increased representation of minority students led racial stereotypes to be actually reduced, because when you are exposed to other people, you realize that the stereotypes you have in your head about someone are not necessarily what they're actually like. And so you find out that they're ordinary human beings just like you, and what you think or what you see on TV is not necessarily the truth about that particular person or that group of people. You always hear, oh, this Black person is so articulate. Well, one of the ways that you get rid of that implicit bias or outright bias is by being in courses or classrooms with Black students that all are quote unquote articulate or speak the same way as you. Not everyone speaks Ebonics or rap language. And so increasing the representation of minority students would help cure some of those stereotypes rather than reinforce them by not having those students there. So next, let's talk about the Jackson dissent, which was a masterful piece of writing. If you're like me and you love legal writing, I highly recommend you read this. Also, as a personal aside, I love the writing of one of our own magistrates here in Louisiana, Mike North in the Eastern District. I suggest you read some of his opinions. They're amazing. If you're someone like me that loves legal writing, both Judge North's and Justice Jackson's opinions are always amazing. She specifically criticized the minority for detaching itself from America's history. Oh, and she says that the majority looks at race consideration in a vacuum, like it did not have a history of slavery, a history of Jim Crow, a history of segregation, those kinds of things. And those are the reasons why we currently have a race-linked gap in our educational system. She employed historical examples of racial preferences to show that the country's never been colorblind. And in fact, there was a racial preference built into the country for Caucasian and white people rather than Black people. And now that the script, or Hispanic people or Asian people or Native Americans, and now that the script is flipped and we are trying to give not even necessarily a benefit to everyone, but just making it a consideration in the holistic view of the application of a student trying to enter college, that now it's no longer okay. She gave a specific example of James, a Black university candidate for UNC, who would like to go to UNC and has to write an application about, write an essay about why he wants to go to UNC. And John in the same situation. However, John is a white applicant who has 6 generations of legacy status because his grandfather was able to go to UNC in the 1800s. And James, who doesn't have that same legacy status, if you can't consider his race, would no longer be able to discuss that. And I'm pretty sure that's why, because of that unique questioning and reasoning that she brought out, why the majority created a carve-out, indicating that while race couldn't be considered in the application, that a minority student could write about the effect of race in their essays to the school, which is problematic in and of itself as a person of color, to have to say that I can only discuss race in an essay. That means if I'm ever going to have my race considered, or any issue, whether it's a disability or something like that, that I have to pigeonhole myself to just my racial issue. What if I really loved AI and robotics and I wanted to write about that, but now I'm pigeonholed into writing an essay about my race? Okay. Next slide. This is probably the most powerful quote from Ketanji Jackson that most people picked up on, and I'm going to read it just because I do think it's powerful. The majority seems to think that race blindness solves the problem of race-based disadvantage. But the irony is that requiring colleges to ignore the initial race-linked opportunity gap between applicants like John and James will inevitably widen that gap, not narrow it. It will delay the day that every American has an equal opportunity to thrive, regardless of race. And I think she's probably right on that point.
Thank you so much, Val. So now we're going to get into to the SFFA decision, right? So needless to say, okay, so needless to say, the court's SFFA decision emboldened a lot of conservative groups and a lot of conservative attorney generals who are anti-DEI, attorney generals of 13 states on that list issued a warning to the CEOs of Fortune 100 companies threatening serious legal consequences over race-based initiatives. So everybody knows, or everyone should be aware, that after the murder of George Floyd in 2020, a lot of Fortune 100 and 500 companies created diversity, equity, and inclusion positions, programs, fellowships, and law firms did the same in an effort to promote and increase diversity within those professions. And so, for whatever reason, those companies, we're seeing that they are getting rid of those initiatives and also getting rid of some of their DE&I officers and teams. And also some conservative groups, such as the American Alliance for Equal Rights, have sued some of these companies, as well as some law firms over their DE&I initiatives. All right. So, again, the American Alliance for Equal Rights, they are suing two international law firms for its DE&I initiatives. I believe have been dismissed because the law firm actually agreed to get rid of their diversity fellowship, which is unfortunate. As I said earlier, the law firms and corporations, they are altering those initiatives out of fear of facing potential litigation. So one of the questions, right, is the court's SFFA decision deals with the public sector, right? These corporations are private corporations. So why in the world the court's decision does not apply? Arguably, it doesn't apply in the private sector. It only applies in the public sector. Why are these corporations running scared, right? I mean, my guess is that those companies, one, do not want to face the cost of litigation, so they're willing to back down. They may have some conservative clients, right, who are threatening to pull the business. Now, I don't know what client that may be, because most clients that I see, they are dedicated to diversity, thankfully. But I'm sure there are other clients who may not be, and they may threaten to pull the business. Maybe those companies, to begin with, they were not very supportive of DE&I initiatives. So this is kind of a scapegoat for them. It's easier for them to get rid of those DE&I initiatives. And Val, I think an important thing, or an important point that I want you to touch on, is what Chief John Roberts said in relation to college admissions in the military.
Right. So if you read the majority opinion, you will see that they, of course, say that race can no longer be considered as a factor in determining whether or not an applicant will get into the school. However, it could still be considered in other areas of federal life, such as the military. And ironically, hot off the press, in earlier this month, February 2nd or 12th, I believe, SFFA sued on behalf of students at West Point, stating that they were illegally using the consideration of race in determining who would be admitted to the college, a military academy. Those of you who don't know, we have 3 military academies. We probably have more, but I know of 3, which is Annapolis with the Navy, VMI for the Marines, I believe, and West Point for the Army. And and the Citadel. So there's 4. And that I know of. If you're in the military, I apologize. I'm sure there are more. But that's the ones I know off the top of my head, that are actual colleges where you go to college first and then enter the service afterwards. And the Supreme Court specifically did not take the case up. They did not want to reconsider the issue. And so military academies are still allowed to use race in their admissions, as the court determined they may have potentially distinct interests. Now, how their interests are potentially distinct versus UNC or Harvard based on only those 2 considerations, one of which you'll remember was about prison race riots, I'm not sure, because arguably the compelling interests or distinct or interests of both West Point and our military academies in considering race would be the same for any other public educational institution or even a private educational institution, because private educational institutions still receive public funding from FAFSA. So that's one that made me go, particularly earlier this month when the Supreme Court decided to not take it up, because I don't know how you justify one versus the other. Okay, next we're going to talk about the impacts of the affirmative action ruling and its effect, because obviously the decision was written so broadly that it could apply in a multitude of different areas and aspects of American life. And you just saw, we included a clip from an article with the ruling that a lot of companies are taking a hard look at their DEI objectives. The main impacts, of course, are on college admissions. The secondary, very large impact is going to be in an employment space, and we'll briefly touch on some cases that have come up since then. And we've obviously seen a rise in reverse discrimination cases, particularly if folks will remember the case out of Philadelphia with Starbucks, and the manager was fired there after an incident with 2 Black patrons being turned away and kicked out of the store. And she contended she was reverse discriminated against, which that term doesn't exist. If you're discriminated against, you're discriminated against. There is no reverse. You can be discriminated against whether you're white, black, blue, brown, whatever. It's just discrimination. However, the public understanding of reverse discrimination is that because she was white, she was reverse discriminated against. Obviously, there'll be impacts in financing and in federal contracting, and we've already seen an impact on the last one coming out of Tennessee, which I'll discuss in the next slide. Let's talk about the employment cases. I'm going to run through these pretty quickly. So we have a case out of New York, a case out of Virginia, and a case out of Ohio. In particular, the first one, Myersberg, a white former executive director at Morgan Stanley, sued his former employer, alleging he was fired and replaced with a Black woman with less experience in violation of 1981. And the plaintiff specifically cited the DE&I program as the evidence of discrimination. That's still working its way through the court at the moment. Then the Bradley et al. Versus the Gannett Company, also plaintiffs who were laid off, sued over its alleged, again, reverse discrimination policy in response to its express commitment to having staff demographics reflect the communities that they cover in violation of Section 1981. And then the third, Farkas versus First Energy Corps, a white male former corporate counsel, sued under Ohio's anti-discrimination statute, alleging that he was fired in retaliation and expressed concerns about the DE&I programs. So you can see that the theme here is that people are using DE&I programs as the sole basis and evidence to say that they were particularly discriminated against. I don't know why people seem to think if there's a DE&I program or if a person of color is promoted, even with less experience, means that they're less qualified. We all bring different levels of experience, different viewpoints from the areas of life. And lest we forget, the point of affirmative action was not to promote unqualified minority applicants. Rather, you almost find that the minority applicants are overqualified because they get nervous about getting in, so they're overqualified to the schools that they apply to. And but everyone else is going to think that they're only there because they're Black and not because they deserve to be there. Which is unfortunate because we all know that just because someone is of another race does not mean that they're not just as intelligent, or have some other area of experience that they're bringing to the table. The next issue, federal contracting. So this was out of the Eastern District of Tennessee, and Ultima Services sued the U.S. Department of Agriculture and the Small Business Administration, claiming that their rebuttable presumption of the AA program discriminated on the basis of race in violation of the Fifth Amendment of the United States Constitution. And the court in Tennessee sided in part with Ultima, holding that the rebuttable presumption did violate the Fifth Amendment, and SBA is enjoined from using it. However, on the next slide, you'll see that the new applications have to provide information on why they have a presumption that they are disadvantaged, and not just because they're disadvantaged because of their race. Can we go to the next slide, Ebony? Okay. So the SBA, after the ruling, temporarily suspended all new 8A applications, which are applications for consideration based on a disadvantage. And their social disadvantage, they had to establish their social disadvantage by completing a narrative. So you no longer got the benefit that you were socially disadvantaged purely because of your race. And so they published a detailed guide. So anyone seeking to get a disadvantage or a DBE loan from the SBA now has to go through an extra step in order to obtain that loan. And next, I know we gave you a lot of history and information, and now we're going to talk about safeguarding our diversity and equity and inclusion initiatives since the decision has come out.
All right. So what are some ways that we can do that? First, broaden the definition of diversity, right? I think historically, a lot of people connect diversity with African Americans. And over the years, it has changed, right? It's not just African Americans, but it's all people of color, women, disabled people, you know, age, all of that is in there. And so when you're talking about crafting a DE&I initiative, don't just craft the initiative to address a particular marginalized group, right? So Val, when she was talking earlier about her undergraduate schooling and just talking about how diverse her student population was, that's a way to diversify, right? You had people from different religions, you had people from different geographic locations, you had different races, different ages, just different backgrounds, right? So that is definitely one way that you can safeguard DEI initiatives in light of the court's decision, is just broaden the initiative and make it race neutral. Okay, another way, and this kind of ties into what I'm saying earlier about diversifying or broadening the definition of diversity. You can create diverse pipelines, right? So a lot of the pipeline programs, and I'll give you one for example. You may have a minority diversity pipeline for law students, right? So that diversity pipeline will obviously be designated for law students of color. But in order to safeguard that pipeline, you can broaden it to include white women, white men, LGBTQ plus community. You know, there are a lot of ways that you can broaden it, right? So you're not faced with one of those nasty letters from an attorney general or from a conservative group threatening threatening to sue your company because the pipeline is not as diverse. Another approach is a blind and holistic view of the applicant, right? So is this applicant, yes, this applicant is a minority, but is this applicant first generation, right? Is this applicant of a different religion, different background? So look at the whole person, right? And not just the race of the person. Also another thing too, you can go to companies that cast wide nets for applicants. I think a lot, in particular law firms, they fall into the trap of going to one source for applicants. And I'll give you a great example. A lot of law firms in New Orleans, they will go directly to one law school, one or two law schools, right? The more prestigious law schools in Louisiana. And at those law schools, the majority are white law students, right? And so obviously those applicant pools are majority white or, majority rich or majority legacy or whatever you want to call it. And they never go outside of those schools to look at applicants, right? Or qualified applicants. So those law firms obviously should cast a wider net, not just go to one or two law schools, but go to all law schools. Also go outside of Louisiana. Look outside of Louisiana. There are several um, recruiting agencies in Louisiana where that not only look for applicants at Louisiana law schools, but they go outside of Louisiana to get other qualified applicants, right? So law firms, they should obviously consider using those recruiting agencies and not just limit their applicant pool to one or two law schools in Louisiana. In the corporate context, right, I'm pretty sure there are recruiting agencies as well that can also cast a wide net for different different corporations and different companies who are looking for diverse applicants. Another way that you can safeguard your DEI initiative is ask your employees, right? I don't know, Val, I don't know if your company does it, but I know my company, they send around a survey that's anonymous. I'm pretty sure it's anonymous, or at least I hope so. But they do send out surveys where they ask questions about, what can we do better? Where are we lacking? What are some ideas that you may have, right? And so that's one way that you can bring diverse ideas into the fold is to talk to your employees. Val, do you want to chime in on any of the points or add anything else?
Yes. So when we were talking earlier about broadening the definition of diversity, I always like to give this particular example. I have a cousin who happens to be a Black male who went to Amherst College, which at the time I think was ranked the number 2 college in the country. And the reason why he got in was not because he was a Black male, but it was because he was from Louisiana. And they had no students from Louisiana at the time. So when you're talking about diversity and diversity of perspective, it is not always race. I'm not sure why affirmative action got so tied to race and it being considered with African Americans, Hispanic, Asian people, because it really does. When you look at the laws that were instituted in the 70s and the original one with Kennedy, it really was for multiple areas, race, gender, and I'm particularly interested in someone potentially challenging D&I policies based on gender because of this suit. We didn't talk about it here, but ironically, there's an article, I think it was in the New York Times, that discusses a potential preferential treatment for male students at Tulane because their student body is now so many women. They are now having lack of men at the school. And so what do you do when you want to have a male perspective in some of your classrooms? But are you going to discriminate on the basis of gender? Is gender discrimination a compelling interest? And then what would qualify gender discrimination to meet a compelling interest that race discrimination does not? Because the Constitution virtually reads the same. It doesn't say women, doesn't say any of the things if you're looking at it at an originalist text. And so the nerd in me is ready for some of the other cases. I believe the NAACP is suing on the basis of legacy status because there are so many schools. Because when you look at entries into schools, I'm not sure why they decided affirmative action was, the evil demon in the room, because in reality, it's legacy admission and athletics admission. That's going to predominate the majority of who's getting into your school, as opposed to a student who gets rated on their entire application and only one factor happens to be their race. So, one of the things, we're getting to the takeaways. I want people to understand that, some people may think in this country that because we had a Black president, or because we are where we are in the country today, that these issues are far behind us, and they're really not. I may look young. When we when we talk to you in the question and answer period, feel free to tell me I look young. However, I am about to be
Me too.
I'm about to be 38 years old. I grew up in a town in Louisiana where, until I was in the 4th grade in 1994, there was a school that I was not allowed to set foot in the doors in because I was Black. That wasn't that long ago. We're talking 30 years ago, which may sound like a long time, but when you think about it, it's not even a full generation that people think like, oh, slavery's long gone. Well, after slavery came Jim Crow and segregation. Schools weren't actually desegregated until the 60s. My parents and grandparents went to segregated schools. And when the schools desegregated, all the white people left, and then my aunt graduated with 3 people, one of which was her twin. So, these aren't issues that have left us, and there are still obviously issues and gaps in this country, which we see all the time through scientific research. So if there was one takeaway, I would encourage people to listen to others, think about how they would feel if the situation was reversed for them, and understand that it all takes us getting to have a civil discourse and knowing and talking to each other. And that is how we will overcome these challenges and safeguard some of these DE&I initiatives.
Yeah. And just to add on that, my takeaway is that despite the fights, despite the attacks on DE, we should absolutely continue to support diversity, not just as a whole, but in particular within the legal profession. It's no secret that the legal profession is the least diverse profession among a lot of different professions. And so without these initiatives, I probably wouldn't be sitting here at my firm. Val would be sitting at her firm, right? We wouldn't be in these spaces because we wouldn't have the support from those law firms or from those different companies of applicants that look like us, right? And so in order to further increase and further grow, we should continue to support these initiatives. However, we have to do it. If we do have to fight back in the courts, then so be it. We have to do it. It is important that we continue to safeguard DEI initiatives, to further promote diversity and further uplift marginalized communities. So that said, thank you. Hopefully you can see our email addresses. Feel free to email us, comment. Definitely tell us that we look young.
That's the math part.
And if you have any questions, concerns, and we hope you enjoyed today's presentation.
Thank you to Ebony and Val for that wonderful presentation. We will now move on to audience questions. I see a few of you have already submitted questions here. Unfortunately, our speakers are unable to join us for a live on-camera Q&A session. However, they did respond via text to those questions that you sent to that Q&A button in the control panel at the bottom of your screen. As such, I will go ahead and read out their responses as well as your questions in full. We'll begin with our first question, which is, by what metrics does one evaluate the success of a DEI program? Valerie wrote out in her response, typically, the main metric is through looking at a company or firm and their practices. If a company is consistently hiring diverse personnel, but that personnel continues to leave, there is likely a reason why those diverse persons continue to leave. Additionally, another good metric is to look at the distribution of diverse personnel throughout the company. If all of your diverse personnel are at entry-level positions, that is likewise an issue. You want to ensure that you have representation at all levels of the company in order to ensure the goals of diversity, i.e., having different perspectives at all levels. Thank you, Valerie, for that additional commentary that you've provided us with, and thank you for that question to our audience member. Our next audience question that we received is, I grew up in an era where there were white jobs, Black jobs, women jobs, and jobs only for men. Do you think that this SFA decision will upend race, gender, etc. discrimination in employment, thereby gutting EEOC, ADEA, and equal pay statutes? Valerie wrote out this response. I think we're already seeing it in the EEOC context and in the commerce context. Several DBE and SBA minority programs have already been challenged and now have a different requirement for consideration. Additionally, there are some recent cases relating to adverse employment actions and the courts finding that an employee experienced an adverse employment action because a diverse applicant was promoted over that employee. Locally in LA, in this instance meaning Louisiana, an interesting study arose with Tulane University needing male applicants. I could foresee the school giving preference to male applicants and that being challenged on the basis of gender as well. Thank you, Valerie, for that interesting food for thought. I love that local example that you gave as well. I'm sure that there are plenty that we could find all throughout the nation. Thank you all again for all of your questions, and thank you to Ebony and Val for your presence and your wonderful presentation. If you have any additional questions for Ebony and Val, their emails were in that presentation. Alternatively, if you would like, we are happy to connect you with them directly or answer questions to the best of our ability on our own. If you email us or contact us via support.justia.com. That is always available to you if you need any support from us at all. Thank you for being here and asking your questions. We do want to thank Ebony and Val and all of you for all of your questions and your participation. Now, as we mentioned at the top of the presentation today, I also wanted to touch on, if you're interested in having updates like the ones that Ebony and Val touched on today about case law delivered directly to your inbox, a great option is our Justia Daily Opinion Summaries. By subscribing, you can receive those updates and daily summaries with key federal and state court developments, as well as tracking developments for your practice area in weekly summaries that go directly to your email. So if you'd like to learn more about that, you can go to newsletters.justia.com. We want to thank you all for joining us today for another Justia webinar. Have a wonderful day, and thank you again for joining us. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.